So welcome to the webinar. Today we are at Legal Aid New South Wales Central Sydney office. Before we start, we would like to acknowledge and pay our respects to the Gadigal people of the Eora Nation, who are the traditional owners and custodians of the land we are broadcasting from today. So legal aid, family law and criminal law policies have been amended to make it clear that legal aid is available for people at risk of or experiencing domestic and family violence. So in this webinar today, we'll be talking about these new policies to give you a better understanding when you help people who are in those situations when they are eligible for legal aid. My name is Natalie. I'm from the Community Legal Education branch here at Legal Aid New South Wales, and with me today are three colleagues. If you joined us for the Grants 101 session, you would have met these people before. So we've got Bridget, who's a family lawyer from the Grants team, and Aideen and Anna, who are from our Clients Eligibility Unit. So welcome to the three of you.
Hi.
Before we start, we're going to do a quick poll to give us an idea of what people already know up front and what type of clients you work with. So the first question today as a practice poll is, do you assist people who have experienced domestic violence who may have legal problems? So yes, it's a big part of my work sometimes, or not much, but I'm still interested. Thanks, everyone. I'll just close that poll now. So as you can see on the screen, 60% of people are saying, yes, it's a big part of my work, and 30% yes, sometimes, and another 10% saying they're still interested. So that's great. We're all in the right place today.
Well, before we get started talking about the policies, we may just briefly talk a bit about domestic and family violence. So the image that's coming up on the screen is taken from a new website. And we've taken some words from this website. It's a really great resource just to explain the concepts of domestic and family violence, apprehended violence orders, and family law that we'll be talking about today. As you probably all know, domestic and family violence is behaviour that coerces, controls, or causes a person to be afraid. DV is often about a pattern of behaviour that causes fear. People at risk of or experiencing domestic and family violence are most likely to seek assistance from the legal system through 1, apprehended domestic violence orders, which can protect a person from domestic violence by setting out rules that the other person must follow. It can help to keep a victim safe by making it illegal for that person to break those rules or to use threats or threaten to use violence against the victim. The second area is the criminal law system, where a person can be charged with a criminal offence like assault. The court can also order an ADVO in these circumstances. These are usually dealt with in the local or the district courts. And the third is the family law system, which covers things like divorce, property settlements and arrangements for your children, like parenting and child support. Family law issues are usually dealt with in the family courts.
Thanks, Anna. And there'll be a link in your email to that new website as well, so do check that out.
So Legal Aid has a domestic and family violence strategy from 2016 to 2018. One of the key objectives of this strategy was to prioritise victims of domestic and family violence receiving legal aid services. So as part of this strategy, we did a review of all our eligibility policies. And as a result, in September of last year, we implemented some changes.
Right.
So the purpose of the changes is to clarify the availability of legal aid for people experiencing or at risk of domestic and family violence. We did changes in a lot of areas of family law, including parenting matters and property matters, child support and divorce. We also had some changes to apprehended domestic violence order matters, criminal matters in the local court, and also migration matters involving visas.
And they're the topics that we'll go through all those in detail today.
Correct. And just before we do that, we thought it might just be useful just to have a quick refresher from our Grants 101 webinar, which was last week. This is just briefly covering off that there are 5 eligibility tests that we use to determine whether a grant of legal aid can be made. So these 5 tests are: number 1, the jurisdiction test. This is about, is legal aid available? Is it a crime, family or civil matter? And it is a type of work that legal aid does. And there might be some other relevant requirements to take into account, such as, is there a substantial issue in dispute? The second eligibility test is the means test. And if it applies to a matter, the applicant may also need to pay a contribution. The third test is the merit test. This looks at the merit of a matter and whether there are reasonable prospects of success. Number 4 is the availability of funds test, which is whether funds are available for that matter. And the 5th is the unpaid contributions test. So legal aid is not granted if a client has an unpaid debt to legal aid.
Thanks, Anna. So now we're going to go into the details about the changes to the policies. So I think, Bridget, you're going to start by talking about family law.
Yeah, so parenting and property matters. Legal aid is only available for parenting matters where we are satisfied there is a substantial issue in dispute. So we thought we might do a quick poll now.
Yeah. So this is just to get your, I guess, guesses or sense first about what you think might be a substantial issue in dispute. So you can see on the screen there, we're asking, which of these matters do you think might be a substantial issue in dispute for family law? Where a child should live, an increase in the number of nights per week a child spends with a parent, a dispute about school, change of name, or a parenting matter where DV, or domestic violence, has been disclosed. You can tick all that you think apply. So which of these do you think are substantial issues in dispute? Thanks, everyone, for your answers. I think I'll close that poll off now and we'll share them, Bridget. So we've got most people, 80% of people saying where a child should live, 30% the number of nights a child spends per week with the parent, disputes about choice of school, about a quarter of the people think that's a substantial issue in dispute, change of name as well, about a third of people think that's substantial, and most people, 90%, that where DV has been disclosed. So do you want to talk about which of those are, in fact, for legal aid, substantial issues in dispute?
Yeah, so it's easier to explain what is a substantial issue in dispute by giving a few examples of what is generally not considered to be a substantial issue in dispute. So where there is no active dispute, for example, where the other party is not seeking to spend time with the child, where the dispute concerns minor issues such as children's clothing, routine, or activities. Disputes about minor increments of time, for example, an increase, decrease in 1 night per fortnight, or an earlier, later drop-off time. Disputes about the changeover location and associated travel costs. Disputes about the choice of child school, method by which the parties are to communicate with each other or the child, change of the child's name, and obtaining orders to enable holiday travel arrangements. So although these are sometimes generally not considered to be substantial issues in dispute, where there is domestic and family violence, these issues might generally be considered a substantial issue in dispute. However, I should mention that where parties are seeking to litigate over the above issues, and there is domestic and family violence, the application may still be refused under the merit test, for example, as it may not be an appropriate use of public funds.
So with the poll question, sometimes the answer is depends, and I guess it was a bit of a trick saying with the DV, because if that's exists, then some of the other issues might become substantial.
Yeah, so where there is domestic and family violence, the issues that are generally not considered a substantial issue in dispute will be where there is domestic and family violence present. However, we were just clarifying that you won't always get an application granted, and that could be under the merit test, but we would consider it a substantial issue in dispute because of the domestic and family violence present.
Thanks. If anyone has other questions around that substantial issue and dispute, just please type those in. Otherwise, we'll move on to parenting and property matters.
So where an applicant for legal aid has a parenting and property matter, legal aid expects that proceedings will be commenced together. And where the proceedings are commenced together, legal aid is only available for a parenting matter where the applicant is also eligible for legal aid for their property matter, unless there are exceptional circumstances. So this generally means that where there are both matters, we will only fund for both where you satisfy the policies for both property and parenting. And Aideen will explain what we mean by exceptional circumstances.
So, hi everyone, just following on from that, and exceptional circumstances for the parenting and property matters would be, for example, where the cost to the applicant of private representation in the parenting and property matters is likely to exceed any financial benefit they will get from that property settlement, and we are satisfied that there are relevant personal circumstances. Another sort of case would be where the applicant is not likely to receive more than $20,000 from the property settlement and requires legal assistance to finalise the parenting matter because they're experiencing or at risk of domestic or family violence. Personal circumstances in the first instance would be where a person has a disability, chronic health problems, or perhaps where the child has a disability. So what we'll do next is we'll bring you through the actual property policy, because those exceptions will only exist where a person has not satisfied the property policy. So family law property matters. So when is legal aid available? So legal aid is available. You have to satisfy the eligibility tests, such as the means test, the merit test, the unpaid contribution test, and the availability of funds test. And then in the actual test for the jurisdiction test, the dispute must relate to matrimonial or de facto home and or superannuation. And the estimate equity in the home or deferred benefit is more than $20,000. And where the dispute relates to the matrimonial or de facto home, the applicant is likely to retain the home unless there are exceptional circumstances. So in other words, a person would satisfy that policy if they have the home, the home that they live in, that's part of the property settlement, and or their superannuation, and the equity in either the home or the deferred benefit is more than $20,000, and the applicant is likely to hold on to the home. So the person satisfies it in those circumstances. If they're not going to hold on to the home, which I would say is probably in most cases, then there must be exceptional circumstances. So, and then the other test we have introduced, which is another change, is that the property can also be about something other than the home or the superannuation, and then there must also be exceptional circumstances. So that there might be sort of investments or other sort of assets that we haven't taken into account. So that's a new part of the policy that we've introduced recently. So what has changed in these property matters? So from now on, there's no requirement to have another family law matter. So prior to September, you had to have children's matter or maybe a child maintenance matter as well as a property matter. Now you can come straight in with just a property matter. The exceptional circumstance test, the new test, is intended to assist people who are experiencing or at risk of domestic or family violence and is more relevant to the property proceedings. The old test didn't really have any relationship to what property proceedings were about. So this is really targeting the issues that arise for people in property proceedings. The exceptional circumstances I just said before only relate where the client is not keeping the home.
Okay, we're just going to do another quick poll to, I guess, test everyone's been listening. So I'll just launch that. So the question is, Vera has experienced domestic violence from her ex-partner. They have no children, but they have property together. Is Vera eligible for a grant of legal aid? Yes, the policies have changed and legal aid is available for property alone. Yes, because she is a victim of domestic violence. No, she doesn't have a parenting matter, or it depends. Thanks, everyone. I'll just close that now and share the results. So, Aideen, I don't know if you think this was a bit of a trick question, but we've got 62% of people saying yes because the policies have changed, and we can have for property alone, 46% yes because she's a victim of domestic violence, and 31% say it depends. And no one said no because she doesn't also have a parenting matter. So that was one of the key messages. Do you want to explain those?
Yeah, no, I think that was answered well. So yeah, that's definitely 100% should be saying you don't need another family law matter. And the DV, you know, that would be something that's taken into consideration. So to assist with that, we'll go to what the exceptional circumstances actually says. So this is when you're applying for property matters. We decide whether you're eligible for aid, where you're not going to keep the home. So this would be, some examples would be where the applicant's experience of domestic violence has resulted in them not having access to information about the property of the relationship. So this is not uncommon, and this is something the Grants Division sees, and it is often in those domestic violence situations that this happens. The applicant is not likely to receive a significant financial benefit from the property settlement, but requires legal assistance because they are experiencing at risk of domestic or family violence, and the proceedings by the other party are pursued as a means of furthering family and domestic violence. So they also there are other issues as well that you can have a look at when you're having a look at that policy in full. So we mentioned a significant financial benefit. So what that means is when we're calculating the cost. So what happens is, as we said earlier, Bridget said that when you have property and children's proceedings, Legal Aid expects you to use the money you'll get from your property settlement to pay for both your property and your children's matters. However, in this work that we've been doing, we recognise that people who are experiencing family and domestic violence often have quite a significant cost, you know, when they want to re-establish a house. And we've done quite a bit of research on that. We looked at ADVOS statistics and also the HILDA stats, which is a household expenditure stats that come out from the ABS, I think, every second year. So we looked at all those stats to see what the cost of establishing a new household would be, and we gave it about a 3-month period because we feel this is at least the minimum time someone would need to sort of reestablish themselves with their children and set up a new home. And that worked out at $52,000, so quite significant really. So what we're going to do is we're not going to take into account that first $52,000 because we feel that's money that this person will need just to establish a new home. We then have a threshold amount which is $80,000, so a contribution will apply between $52,000 and $80,000. And once you get to the $80,000, so in other words, if your client's property settlement is going to be over $80,000, we will consider this to be a significant financial benefit.
And the idea then is that they can pay for their own legal representation.
That's the idea, yes. But I mean, if you have a client who you feel is really, there's always people, even if they're going to get more than 80,000, that you feel their experience is so sort of terrible that you can always speak to the Grants Division and have a discussion with the grant solicitors about whether they would fit within our new tests.
So moving on now away from property to other areas of family law and what's changed in the policy. So I think, Bridget, you are going to talk about child support now.
Yes, so legal aid is available for appeals to the Administrative Appeals Tribunal to review a decision by the Child Support Agency. For legal aid to be granted, the applicant must satisfy the means test, the merit test, the unpaid contributions test, and the applicant must also be unable to adequately represent themselves before the AAT. The policy has been amended to make it clear that experiencing or being at risk of domestic and family violence will be taken into account when considering if a person can represent themselves, and also things like administrative assessments where administrative assessments cannot be made, for example, for children over 18 years old, and child support parentage matters and arrears of child and spousal maintenance as well. So we do have a child support service, which is a specialist service which is part of legal aid, and they provide advice to paying parents who have to pay financial support and to parents and carers who should be receiving financial support. So I'll just continue on to talk about divorce and nullity of marriage. I'll just explain the difference. So an annulment of marriage is basically a legal decree that a marriage is null and void. Annulments are granted when a court makes a finding a marriage is invalid, whereas a divorce ends a legally valid marriage. So an annulment treats the marriage as if it never existed. So that's the difference between a divorce and an annulment. So as you can see from the slides, our old policy, you needed to have, there were more requirements to satisfy. So basically, you need to satisfy the special circumstances that existed, and that a court application is imperative, and the applicant is at a special disadvantage, and the complexity of the application means it is unreasonable for the applicant to conduct the proceedings. Whereas now, for aid to be granted under our new policy, legal aid must be satisfied that it would not be reasonable to expect the applicant for legal aid to conduct the proceedings due to the complexity of the matter and the personal circumstances of the applicant. And then I'll also note that the service is usually to be provided by in-house unless there are exceptional circumstances. And these exceptional circumstances are where in-house practice has a conflict of interest or does not have the capacity to take on the matter, or client is unable to access a legal aid office, and this is definitely prominent in regional areas. So you still must satisfy 4 eligibility tests. So it means merit test B, availability of funds and unpaid contributions. So in the next couple of slides, we'll talk about what we mean by complexity and personal circumstances. But the basic result of the change is that we can assist more clients with their divorce matters. So please refer those clients to us if their situations are in the categories we will explain next. So the following types of cases may be considered complex and warrant legal aid. Language barriers, which may affect the applicant's ability to properly deal with the court system. Difficulties in proving the marriage, a need to obtain recognition of overseas dissolution, a need for substituted service, a need to dispense with service of the application, or the applicant is subject to a forced marriage. So this captures the key situations where an applicant requires representation due to the complexity of the application. We have now added a further circumstance or forced marriage. So I'll just discuss the personal circumstances. So Legal Aid New South Wales will be satisfied that the applicant is disadvantaged due to their personal circumstances where the applicant is experiencing or at risk of domestic or family violence, or has an ongoing health condition or disability, or is currently experiencing significant financial hardship. This new test will ensure applicants who are experiencing or at risk of domestic violence are eligible to obtain assistance with their divorce. This new test will better capture the applicants we want to assist, for example, domestic violence victims. Significant financial hardship, this needs to be a high bar. Obviously, all clients experience financial hardship if they satisfy our means test. So this test is more than that, and I believe we're going to go to a poll now.
Thanks, Bridget. Yes, there's just a little scenario on your screen there, which I'll read out quickly. So Sarah was married overseas and she has limited English language literacy. Sarah experienced significant domestic violence from her husband while they were living in Australia, but she never went to the police or reported the abuse to anyone while they were together. They have now separated and Sarah wants a divorce. She does not know where her husband is. So the question is Sarah likely to be eligible for a grant of legal aid to assist with her divorce? Okay, well, that's a very definitive response. We've got 93% of people say yes and 7% of people say it depends. So, Bridget, do you want to explain in Sarah's situation, would she be eligible?
Well, I think everyone's definitely been listening very well, because yes, so under our new policy, Sarah would be eligible for aid in the divorce policy. So she satisfies the complexity because there's a definite language barrier there. And also in terms of personal circumstances, there is domestic violence, a history of domestic violence. And also there could even be financial hardship as well. She might be suffering, but yes, so she would satisfy our divorce policy. So well done, everyone.
Thank you. Before we move on from divorce, we've had a question about, I guess, religious annulments or religious divorces, whether that is relevant. I guess that's something the lawyers would turn their minds to, but here we're talking really about legal annulments or legal divorces under Australian law.
Yes, so in our divorce policy, although we've amended it to make it easier for people who are experiencing domestic violence to get a divorce, we are really strict within our guidelines. So it'd have to be, a legal divorce or an annulment in terms of like illegal. I don't think we would cover those types of situations.
Thank you.
So moving on to the changes to criminal law policies. And just to be clear first about the title of this slide, as many of you know, ADVOs are actually civil orders. They're not criminal matters, but at Legal Aid, ADVOs sit with the criminal law policies. As part of these changes, we have removed separate policies we used to have relating to cross applicants. So now what we have is one policy where a person is an applicant for an ADVO, and another policy where the person is defending an ADVO. We have removed the unpaid contributions test, which means that owing a debt to legal aid will not prevent an applicant from receiving assistance for an ADVO matter. And we have also made it clear that aid is available to victims of domestic violence. So this applies whether they are applying for an ADVO or defending an ADVO. Aid is also available to defend an ADVO where there are exceptional circumstances. So exceptional circumstances is not exhaustively defined, but it does include where the person is at a special disadvantage. And a special disadvantage is defined as a situation where the applicant is a child, or where the applicant for aid has substantial difficulty in dealing with the legal system, and this could be by reason of a psychiatric condition, a developmental disability, an intellectual impairment, or a physical disability. So ADVOs apply in situations where there is a domestic relationship. Our guidelines have a definition of a domestic relationship. We have some examples here for you. That's where people have been in an intimate relationship, married or de facto. It can also be between two people who are resident in the same residential facility, or relationships between carers, both paid and unpaid, and between relatives or extended Aboriginal kinship groups. We have recently added a new category to domestic relationship to reflect changes in the law in New South Wales. The wording is a little bit tortured, but really what it means is that a current partner and an ex-partner are considered to be in a domestic relationship for the purposes of ADVOs, even where those two people have never met. So that can be a situation where a woman's ex-partner and current partner, there can be an ADVO between those two people in certain situations. It's also good to point out as well is that situations around elder abuse do meet the category of domestic relationship. And the other requirement is that aid is available where the applicant for aid is a victim of domestic violence. This is whether they are defending or applying for an ADVO. I should say in most circumstances of applying for an ADVO, often it is the police who will bring an ADVO application on behalf of the PINOP, which is the person in need of protection. But there are some instances where people choose not to go through the police, and we can assist them to bring an application for an ADVO in those circumstances. So we will be satisfied that an applicant for legal aid is a victim of domestic violence when some of the factors under our guidelines are met. That includes where their application is supported by a domestic violence worker or a community worker. This list is quite broad in terms of what we would sort of accept in this category, but it doesn't need to be too onerous. So things such as a letter or a telephone call can count as support.
So if people are community workers listening today, it's quite a broad definition if they work for a
correct, yes,
community organisation,
yeah,
or Women's Refuge.
Correct. We cover issues like social housing, tenancy workers, housing workers, and the idea of providing support is, like I said, not meant to be onerous, so something like a telephone call would be sufficient. It can also be, we can be satisfied an applicant is a victim of domestic violence where they've previously been an applicant in an ADVO matter, where they're currently living in a refuge or alternative accommodation due to domestic violence, or whether they have some other evidence that can support their application. And then the final change for the criminal matters to talk about is we have introduced a new guideline around local court matters. So legal aid is available for a defended hearing in the local court where there is a real possibility of a term of imprisonment being imposed or where there are exceptional circumstances. So this is where somebody has been charged with an offence such as assault and they are defending that and pleading not guilty. What we have done is we have clarified the guidelines in these matters to make it clear that we will consider that there are exceptional circumstances where the applicant for aid has been charged with a domestic violence offence and where we are satisfied that they are actually a victim of domestic violence. This can be circumstances where this happens is perhaps where a woman might be charged with assault against her partner, but we're actually satisfied that she is a victim of domestic violence. It can also cover situations where perhaps a young man, like an 18-year-old son, is charged, but we're satisfied he's actually the victim of abuse from one of his parents. Or there could be other situations, say, where an elderly man is charged for assaulting his carer, but we can be satisfied that he is actually a victim of elder abuse from the carer. Yeah, that change has come there.
Thanks, Anna.
So as part of the reviews, when we were introducing these new policies in June 2018, the federal government stopped funding for our refugee and migration matters. This was a funding arrangement we had in place for about 15 years. So to ensure that we could assist people, particularly those people experiencing domestic violence in relation to migration matters and particularly partner visas, the board approved a change to the policy in civil law matters, making legal aid available for a partner visa application where the applicant is eligible for an exemption under the family violence provisions, child of the relationship, or death of a sponsor exemption provisions. So the only difference here is this work is only done by our in-house team. So if you have any clients who need to get advice, those solicitors are available to give advice, and then they would make a decision whether they can take on that matter as a grant of aid. It will depend on their capacity sometimes, but this was an important policy, recognizing that some some people who come from overseas are often threatened in that relationship of being reported to the Department of Immigration. And often they are people experiencing quite significant domestic violence. So it is really important, if you come across any of these women, that you do contact our civil law division and they can provide assistance in these matters.
Thanks, Aideen. Did anyone have questions? We're going to just wrap up now and talk about some key messages and where to go for help. So please start typing in the messages and we will be answering those shortly. So where can people go for more information? And I think these links will all be in the email that you get after the webinar.
So we have an A to Z on the Legal Aid website, and this will just have sort of an easy sort of you go to matters like adoption, like migration. So it sort of talks about in sort of plain language the type of matter. I think it's up there now on the website. We're actually reviewing this at the moment as well. So if any of you have any feedback you'd like to give us, we would welcome that feedback. But that's a really good resource. We also have the policies in brief, another useful resource for people to understand when legal aid is available. And then, of course, the reminder of the website that Anna spoke about earlier, Family Violence Law Help, which is, as Anna said, an excellent resource for people experiencing domestic violence.
So, Bridget, did you want to talk through the key takeaway messages? And then I can see some questions coming through for you. So we'll just wrap up by the key messages.
Okay, so new policy started in September 2018. So to be clear about when legal aid is available for people who have experienced domestic and family violence. And these changes were made to family law policies for matters involving property, parenting, divorce, and child support matters, to criminal law policies for ADVO matters and defendant hearings, and to civil law policies for migration matters. And of course, it's always a good idea to talk to a lawyer first before applying for legal aid. Even if people think they might need representation, it's still a good idea to see a lawyer first rather than just fill out the application form. People can get free legal advice and minor assistance without a grant of legal aid.
And these are services that we have mentioned today. Are these the main places where people should go if they've got clients who have experienced domestic and family violence?
Yeah, if you support people who have experienced domestic and family violence, please refer them to us. Links will be in the email you get after the webinar too, and we've got some websites listed on the slide as well. We've got the DVU website, the FAS website, and the WDVCAS website.
And of course, there's also LawAccess and community legal centres that can help people as well. I'm just going to do a quick final poll. I guess this is a super quick evaluation of what we all learnt today. Just after doing this webinar, do you feel more confident to help clients understand getting legal aid, and particularly these new policies? Great, thanks everyone. I'll just close that now. So we've got, 88% of people said yes, they feel more confident. So I guess that's what we were trying to do today, and 12% sort of. So I guess these are really complicated areas.
Yes.
There's, so many resources and policies. It is a really tricky area to get your head around. So I think that's understandable.
Yeah.
But thanks everyone. All right, so that's the end of our presentation, but as I said, we're very happy to answer questions, and we've got some questions coming through already. I think this first one was for Bridget. How quickly will legal aid applications be assessed when domestic violence is present?
Well, we really try and assess those applications urgently. What usually happens is where there's an application that has serious domestic violence present, usually the solicitor who is submitting the application on behalf of the client, or the community worker who's assisting the client, they can call grants and they can say, look, there's an application that's been submitted on behalf of this client, there's serious domestic violence present, and it's quite urgent. And then we will look at that quite quickly actually and assess it. Obviously, we still need to be satisfied that they meet the eligibility requirements, but we do assess the applications that do have that urgency quite quickly. We do try and look at them the same day that we get the urgent expedition request.
Thanks, Bridget. There's a few comments about thanks for an informative presentation, so well done, but I'm just waiting for any more questions before we say goodbye. Did you have any final comments, Aideen or Anna, while we're waiting for any more questions?
I'll just mention that if you weren't present for the Grants 101, just in terms of our community workers assisting clients with filling in their applications. So it's always helpful if you're assisting a client fill in an application that you ask them basically what's their matter about, what are they seeking legal aid for, and why are they seeking that from legal aid? And then you can just assist them also even in filling in their financial section correctly. So putting in their financial details. Are they on a Centrelink benefit? If they are they on the maximum benefit? Do they have access to their Centrelink income statement and financial documents, and even any court documents that might be relevant to their matter? And if you attach those to the application, it always assists the grants department in assessing these applications, because it means that we don't have to send out a requisition to client because we already have the information there, and it does assist applications moving more quickly.
Thanks, Bridget. All right, I think we will leave it there. So thank you very much. And as I mentioned, this will be a recording on our Legal Aid YouTube channel. So if you have colleagues who missed out on the live webinar today, they can catch up on the recording. So if you're listening to a recording on that note and you have any questions, and the email address to contact us, and we can forward it to the relevant people is cle@legalaid.nsw.gov.au. So thank you everyone for joining us today and for your participation, and we will see you next time. Thank you.
Thank you.